Now just hold it. It should come on.
Okay.
Mm-hmm.
I don't know what you were doing wrong.
Am I just going to be on by telephone?
I don't know. I don't know if you're just going to hear them or it'll open the screen up. Let's see. I don't know what's going to happen. But you're on speaker, so.
Okay.
You don't have to hold it to your ear.
Oh, am I on mute?
No. Once we get off the base, so you're going to have to give me directions.
All right. Well, it's 4 o'clock. Hello? Is anybody there?
Yes, we are here, and it is 4 o'clock. You're right. So I'm going to call this meeting to order. This is a special meeting of Smithfield Township Board of Supervisors. We originally scheduled this initially just for continuation of the public hearing on Water Gap Capital Partners, LLC conditional use application, but we're going to begin with a proposed ordinance prohibiting parking, on-street parking on a segment of State Route 209, and then consider that. Doug, would you like to give a brief overview of that ordinance?
Sure. My name is Doug Olmsted. I am the development manager for DEPG. As part of the overall Smithfield Gateway project, the HOP that we're getting for the traffic improvements along 209, one of the conditions from PennDOT in order to get that HOP, we have an ordinance passed by the township that does not allow parking along 209 in the areas of proposed improvement. The township did have a no parking on file. It's called Chapter 15, entitled Motor Vehicles. Under Section 203 of that chapter, there's a section that talks about where parking is allowed and not allowed. There was a portion of 209 that had no parking on it, and this ordinance is just that section of 209 to include no parking in the intersection of 209 and 447 up to just past the intersection of Hillside Drive. So in that stretch, which is where the overall improvements will be, into the Smithfield Gateway project,
Just a moment before we proceed. You're on the Zoom call and you're not at the moment. Could you please mute yourself?
I think that means me, Marshall Anders. I'm not visible apparently.
Well, we can hear you, but hold on. We're just going to proceed to on this hearing before we get to yours.
Mr. Chair, you should be aware that this is not a zoning ordinance and local ordinance, so don't have required to be advertised on time. That was advertised in the public record on February 23. A copy of the ordinance being given to the public here for review. A tested copy will be filed with the law library soon as the ordinance that is ready to go. I think even just as a courtesy, the Monroe County Planning Commission reviewed this ordinance too, which was really, again, not necessary because it's not a zoning ordinance, and I believe that they gave it their blessing also, if I'm not mistaken.
Right, as did our own Planning Commission. So, at this point, since that's all in the record, I would ask for public comment before the public hearing on this matter be closed. Anyone on Zoom or here in person have any comment on draft ordinance 240 prohibiting on-street parking on State Route 209 near Hillside Drive? Discussion from my colleagues? Okay, do I hear a motion to close the public hearing?
I'll make that motion.
Motion by Brian Barrett, is there a second? Second by Robert Levenheim, all in favor?
Aye.
Aye. And we'll now entertain a motion on the overall ordinance. Okay, motion by Robert Levenheim, is there a second? Seconded by Brian Barrett, all in favor? Aye. Okay. We can sign this after the meeting, but we have it right here.
Okay, thank you very much for that, and it's good housekeeping on some of the other issues that we've recently had. Arrangement, subdivision plan.
Perfectly fine. Do you want to a little bit of a rehash of the traffic signal easement, just so everybody understands? I know that we had got them on the 22nd from Marshall.
traffic signal easement. There's a drainage easement so that the house won't be maintained. That's to be addressed as part of the overall development. However, this easement sets aside an area that's necessary areas where the township would be able to go in, their contractors. So this right in the ability to
Hold on one moment. If you're on the Zoom, could you please mute yourself? If you're driving or even just sitting, we hear the feedback, and I don't want that for anyone that's trying to listen in or is here in person. Thank you very much. Okay. Thank you, Doug. Ron, John, do you have any comment to offer on the traffic signal?
No, I've reviewed it. There is some boilerplate that I'm going to probably send to Mark. I confirmed with Mr. Olmsted just before the meeting started as to what exhibits go with what, because Mark sent me the exhibits first, and then he had sent me the agreement, so they weren't sort of attached. But Doug is always as smart than me, so he was able to tell me what numbers went with where. So I'm okay with those. I have not looked at the joiner deeds yet, though. They came this afternoon, maybe around 3 o'clock.
Yeah, I haven't looked at them either.
The only comment I have on the traffic signal, I've checked descriptions against the plans, and that they seem to be okay. I think maybe part of Ron's confusion was, though, we have a description that's titled Exhibit B, when in fact the exhibit itself that it's describing is described as Exhibit A. So we may want to get that fixed up.
I think in the agreement, what they say,
in the agreement, the map
they
or
refer
title
to
is Exhibit A, and the descriptions are referred to as Exhibit B.
the easement on the plot plan is described as the plot plan Mark A, and more particularly described in Exhibit B.
Okay.
So they're doing a map and they're doing a meets and bounds, bearing and distances, et cetera, which is what I would want. I usually want both in an easement, so that's okay.
Then I have no other comments. The legal description matches the description shown on the exhibit.
And this is standard.
Yes.
Great. Well, thank you. Do either of my colleagues have any questions or discussion on these? Okay.
Do you need to pass a motion on the traffic signal easement so that Jacob has the right to sign those documents?
There are some additional paragraphs I want to add.
Subject to legal review?
To do that, if the board wants to do that. I'm going to just add a couple boilerplate paragraphs, and have Mark intertwine them into the agreement.
That's fine. So we would ask then for a motion to approve the traffic signal easement so that Jacob can sign those subject to legal.
Do I hear a motion to that effect?
I'll make a motion.
Do I hear a second?
I'll second the motion.
All in favor? Aye.
Legal review.
Now again, Jacob, that means the documents that were given to the township, those are not the ones you signed.
Right.
We set prepared, assuming Mr. Wolf agrees with the additional language that I am proposing.
Right.
Okay.
Yep, makes sense. Without your approval, that nothing's going to be signed like that. Okay. Well, thank you, Doug,
I have nothing else unless the board has any questions.
Anybody have anything? Okay, well, thank you very much.
Thank you very much for your time.
Alright. We'll just give them a moment. Robert, when you pass the computer, can you move the mouse off of the stop video button? Yeah. I feel like that's a bad omen, having the mouse right over the stop video button, so we're going to make sure that that's not the case. Very good. Thank you. Okay. Seeing that that is concluded, now I'm going to call reopen the hearing now for the conditional use application for Water Gap Capital Partners, LLC. Just before anything gets started, before I turn it over to Ron, I just want to thank you all for sitting here for that riveting discussion about traffic signal easements for this matter. Okay, Ron?
Yes, well, we are here from the last public hearing that was held on February 9 of this year. At that time, the matter was scheduled for February 9 for a vote by the supervisors on the application. In the interim, we meaning the board, had received letters and emails from various individuals on both sides of the issue with respect to this matter. So a motion was made by the supervisors to reopen the record and to also take testimony. And because of that reopening of the record and the motion to take testimony, the 45-day decision date was told, because obviously the record is still not closed with respect to this matter. So that being said, the matter was put over for today to determine whether or not either the applicant or the neighbors, protestants, objectors, whatever you may call them, I apologize if not using the proper term, but whether either of them have any live witnesses to present, and then the board can also consider whether or not any written statements that have come in either before or since our hearing on February 9, whether you want to make them part of the record. So that's what we're here for today.
Okay. Well, I know we did receive a number of communications, I think some from employees of Water Gap Wellness and others from members of the community. I know I had sent them to you in an email earlier, Ron. You want me to just name them off?
Yeah, name what we've received, and then we can go from there. And I'm sort of sorting out my packet here as we talk. I have 4, unless I miscounted. Go ahead.
Well, the latest one was received from Al Siliberto, the clinical director at Water Gap Wellness. That was received earlier this morning. One from Ryan Brady, who I think is a marketing officer. One from Marty Bartholomew on February 9th. One from Annette Kaiser on February 24th. And Ryan Brady. So that should be the 4.
That's what I have, and just so the record is clear, the one from Mr. Brady, who is noted as the Chief Marketing Officer of Water Gap Wellness, that was received on February 22nd.
Oh, okay.
Board of Business has determined whether or not the board wants to make these matters part of the record. Doesn't have to be the first order. I guess it could be the second order. I guess see whether any live testimony is going to be presented.
Sure.
This afternoon.
Sure. Counsel?
Yeah, on behalf of the appellants in this case, we have 3 witnesses. Darrell Strunk, who indicated at the last meeting, has written penned an email to the township. We have Heather O'Donnell, who is a former employee of the facility. We have Terry Fagan, who will testify in accordance with the email that he sent to the board. And if possibly, I may recall very briefly Diane Delafana, who testified previously in this matter. We did make an effort to contact Jasmine Mosley, who's one of the individuals that wrote a email to the board, and we were unable to reach her for purposes of her testimony here tonight, so we do not have her testimony. I would further note that I just don't believe that we've ever seen emails that, or letters, whatever they were, that you just read into the record. I think we have to treat everybody the same, and if we're going to let emails in, we either let them all in, or we have people here to testify. I think the idea the last time was to hear testimony from the people, not to arrange for that, so you could hear some testimony. These other folks have their email. I don't know if they're available to testify. I mean, my understanding was that we were going to limit it to the people that were mentioned the last time around, and if there were other individuals, we were to be given advance notice. I did notify Mr. Wolf yesterday, whom my witnesses were. I had no idea about these other individuals, who I assume were in the current employment of the, whatever you put, the inn, or the Buttergap Wellness, whatever we're calling it now, or PA Nights Homes, that we have certainly not seen any communications from any of these people. I've had no knowledge of them before you mentioned it 2 minutes ago.
I'll just respond that there's a number of mails that have been sent in, including some ex parte communications from parties that have come in and sent directly to the supervisors here. So I think it's a little bit hard to rein this in at this point. Essentially a free-for-all for people writing letters in even after the record had been closed. Reopened. My understanding was that it reopened for options to have additional testimony if it was felt that was necessary. I didn't interpret that to mandate that anyone who wrote a communication to the supervisors would be required to testify.
I think that being in receipt of them and having them being made part of the record are two different things. Aside from not having seen them, this was a problem I think we touched upon the last time. That, I could send an email in with using somebody else's name, and I didn't know the difference. We could take the email in, as opposed to having somebody here testifying, saying, I'm Joe Jones, here's my testimony. So I think it's a significant difference, and we're also a little bit blindsided. We had no idea that there were additional.
Until he's talking.
Right, the emails were inherent. Can't appreciate it, as Jim said, but even more to them, they're one-sided without us having knowledge. And I understand that whoever came in today, the board has no ability to share, but like some of the others came in several days or even a week ago.
It'll be up to the board to decide what it wants to do with the emails. The
I
rules of evidence do not apply to this hearing, so I'm not sure where that all washes out. I agree that if you're going to let written emails in, then they all come in. I agree with Mr. Ferrari in that. If you are going to
Just a picture of him, though.
Yeah.
just want to hear testimony, you can do that too. Again, I believe that feel such that you accept them for what they're worth. The reliability, so to speak, goes to their weight. How much weight do you want to give them? But as to their initial admissibility, whether they even come into the record, I think they do if all the other ones come in too. But again, I agree that if council has not received them, that they should get an opportunity to look at them and probably come back another day again if in fact they want to challenge what's being said in those emails.
if I'm not mistaken, and my memory may not serve me, I thought this day was like the last day for this, and believe me, I want it to be the last day.
Yeah.
We're so this as much as you fellows did. My understanding was we were coming back to testimony, and that, and Mr. Karasak, I think, said we were going to have this.
Hold on. If you're not speaking, can you please mute yourself? We don't need the background noise during this proceeding.
Expressed a concern about.
Can you mute whoever that is?
I said, no, we're going to have one hearing, and that's going to be it, and the witnesses are going to testify. They're either going to come and testify at that hearing, or that's it, and we're going to close the record. Now we have all these other emails that we haven't even seen, and I just think it's inherently unfair to us. We went through the trouble. We arranged for these people to appear to testify. Now we're just going to let in all these other, 11th hour emails, which I think is contrary to what we talked about the last time.
Just a suggestion, the people who are here to testify will testify under oath.
Absolutely.
And these letters are just submitted, but they would not be submitted under oath.
But they're not only submitted not under oath, we don't really know that they're, like Mr. Lehman, that we can't verify even that they were written by the person whose name is on.
When we take a break from it, I'd just like to talk to our counsel about this.
Okay. I suppose we'll recess to executive session. I'm just going to mute this in here, and we'll return. Right, well, I'll unmute us now. So in that executive session, we just decided to Xerox copies of those communications, recess this for another 15 minutes or so to allow you to examine them, and then we'll go from there. Ron can explain it more in depth, or perhaps in a different way than I just did, but that's how we're going to approach this. The goal of this is not to create an inherent unfairness in these proceedings, and it's also not to delay them to no end either. So Ron can explain more in depth, but that's where we are.
Andy, just to be clear, that's Mr. Filiberto?
Al Filiberto, Ciliberto, and
Brian Brady?
Brian Brady and Annette Kaiser.
Nice, Kaiser.
Kaisser. I do not have the letters from Brian Brady or Annette Kaiser either. I received late this afternoon the letter from Filiberto. That might take sure.
I guess that Ron's copying.
He's copying all the things that I mentioned. At least that's what I believe he's.
At least something to read while we're waiting. You're gonna finally get it to a pretty consistent.
Well, we'll know when we see him, Andy.
Good enough. I don't know, I just don't need to hear it.
definitely.
All right, the record should reflect that the, supervisors are back after executive session discussing with counsel attorney-client privilege matters. And I believe that, what the supervisors are going to do, they would need to take a motion out in an open meeting, is to, recess the hearing for a bit to allow these items that have come in to be shared with counsel for them to look at it, and then, once they've looked at it, they can re-raise objections or position they want with respect to the. That being said, you can entertain a motion to recess to allow this to occur, Mr. Chair.
Do I hear a motion to that effect?
I'll make a motion for a 15-minute recess.
I'll second that motion.
Okay, second by Mr. Barrett. All in favor? Aye.
Let's do this.
Yeah.
So that we can keep a track on what's what.
Right. We're gonna make that room available. We can also, if you wanna review it separately, we can make sure.
I think we can just do it from right here, I think so.
Oh, okay.
Mark these. In the order that they came in.
I don't know what we're up to.
I'm not sure either. Don't have my transcript, so.
So what I can do is I'll just put them on here, and while we're taking a break, maybe we can figure that out. You wanna make them board exhibit, how?
Yeah, I'll make it board exhibit for right now.
At this point, since we are, going into recess, I'm gonna mute the, microphone. So nothing's going on until we announce that there will be something. Thank you. Go ahead now, Jim.
Marshall, are you on the line? Marshall, are you on the line?
Muted. It's not muted, if he was the party that was making that background noise, if he's not sure how to mute himself, if he's on a different computer, that's what he would struggle.
What is she doing? Am I moved here?
I think you're on, Marcia.
Can you hear me? Ron, can you hear me?
Yes, Marshall, we can hear you. Hey,
I think they were marked at the last time, and we're Ward 7.
Mr. Ferrari, Mr. Anders, I think, is on the line now.
I am, thank you.
There are, letters from, looks like supervisors at Water Gap, Wellness that are being proffered as exhibits. And I and Peter are looking at them right now. If I email them, can you get them?
January, February 9th. I don't think there was some show to it.
How do we turn the volume up?
Mr. Anders, do you have an email that we can send you the documents at? I don't know if you heard what Mr. Ferrari just said.
No, I didn't hear what he just said. Now, I'm in a hotel in Jersey, so I don't think we have any email.
I'll send it to you.
Huh?
I sent it to mine.
Yeah, I guess you can. You can send them to pdcleh, Kleh, @gmail.com.
You said pdcleh, Kleh, @gmail.com?
Yeah, it's P as in Patricia, D as in Diane, K as in Kilo, L as in Lago, E as in Echo, H as in Hotel, @gmail.com.
Okay, perfect. I will forward it to you now.
This is my set, Peter, you're welcome to look at them if you want. What is it? My set. No, I haven't looked at it. I'll look at it. Thank you, Donna.
You're welcome. Any opportunity to stand up.
Okay, Marshall, I've just sent you forwarded you 2 emails that should have all of the attachments that we're talking about.
Thank you.
Thank you. And then at this point, I'm going to mute us just so we don't have any interference, but let us know if there's something up.
Yeah, I just want to find out. Ah, shit. Remove this. Like shit.
Did you finish reading?
No. Okay. That's it. Nothing more. Can you go back to the first one?
There's more. Do you want to this?
Yeah. Is there any more? Any more, dear? Is there another?
No, you want me to go back to the first one?
So a later one after this or is that the end?
That's the,
Yeah, go back to the first one. Shoot. When was the last meeting here? Do you remember?
All right, well, 4:56, so it's been about 15 minutes. So at this point, I'm going to reopen the record here. Ron, how do you wish to
Okay, well,
proceed?
we provided council an opportunity to read the emails that had come in. There were 4 of them, comprising perhaps maybe 5 or 6 pages. And they were afforded 15 minutes to review. So now it'll be up to council to tell us what their objections are to these documents, if they have any, and then at that point, the board will have to make a ruling as to what they want to do with the emails. I will tell you that if in fact the board is of the opinion that these emails come into the record then I believe all the prior emails that have come in this matter also come into the record, even if those individuals are gonna testify too. So that being said, Mr. Wolf, what's your position with respect to the emails?
Well, first of all, just to clarify, the three individuals who have written emails in support, of the Water Gap Wellness Center, that would be, B8, 9, and 10 are on the call. With respect to B7, my understanding was, I believe Mr. Bartholomew's here, my understanding was he had previously given, public comment in these proceedings. I'm not sure why we need to have that again, but if we're going to admit the ball, I have no objection to that. But I can present the three authors of these, emails, to testify as to their veracity.
All right, counsel, for the neighbors and or objectors, what's your position now that we've heard what Mr. Wolf has to say?
Well, sure. And I was looking over the February 9th transcript. When the record was reopened, it seemed to me very clear that the supervisors, and I understand the reason for this, didn't want this to become a never-ending story. And it appears pretty clear to me that the purpose was to reopen for the testimony of the people identified who had sent emails on February 9th. So I would object to testimony for anyone other than the people identified, who, at least two of those we have available today, in the February 9th hearing. It was reopened for a very limited purpose. I would also object to, frankly, admitting any of the emails as emails, because emails are inherently unreliable. They cannot be. I understand the normal rules of evidence apply, but some rules have to apply. They're inherently unreliable. We don't even know for sure that they were authored by the people who said they were authored. They can't be cross-examined. Mr. Wolf can't cross-examine an email submitted by people favoring our position. We can't cross-examine the people that submitted the last-minute emails on behalf of Mr. Wolf's client. So I think our position would be this was reopened for a limited purpose. It was to be the last time, and we should limit ourselves to testimony by the people identified in February 9th. And we would object to any emails being submitted.
And can you point to the record page in line where it says that it's being opened solely for the purposes of the witnesses?
It doesn't say that explicitly, Ron.
Well, okay, that was my whole point when I read the transcript before I came here today.
And you're correct.
It doesn't say that.
That it doesn't explicitly say. But there was a couple statements, and of course it's up to the supervisors, and I understand the statement, okay? There was a statement on 3 minutes, or 1 minute.
I don't know if someone's watching some television, but if we could keep that on mute in the background.
Actually, Mr. Wolf said correctly, I guess it's my concern, Mr. Karasek, that these proceedings can be delayed indefinitely by every resident of the Delaware Water Gap coming forward that is not spoken after the record has been closed, and we just keep reading the record. Mr. Karasek, this is page 291, Mr. Karasek, I suppose that makes a good point. However, I think the board, in dealing with this board, they're not going to make the hearing a mockery to the detriment of your client. I think they're opening the record now because this stuff came in. Fine, we're going to hear it, but if after they close the record,
someone else wants to now put their 2 cents in, I'm going to recommend that they don't reopen it again, because everyone should be on notice now of what's happening. So if they want to testify, let them come now or forever hold their peace. Mr. Wolf, and that's the point, with all due respect to Mr. Ferrari, the last comment is open-ended. If more people come forward, where's the end of this? Now, that's a valid point raised by Mr. Wolf, and it's a valid point raised by you. We have to raise the need of this at some point in time.
If after the testimony is closed, people come in, I will tell them, no, the testimony is not closed as to here, right?
So, Mr. Karasek, we've had a number of emails that have come in through the start of this hearing. Why don't we cut it off there?
Can I be heard?
Yeah, go ahead, Marshall.
Yeah, these emails that were submitted, I don't think any emails that were submitted after the last hearing should be admitted, no matter whose side they're on. They were just written because of the emails that came in before. And therefore, I don't think that they should be considered. Everybody had an opportunity before that to respond. In addition, these emails that came in from the Wellness Center don't say anything. They brag about their individual credentials. Then they say, Schlimm is a good guy. And then they say, we need this, but they don't address and have not addressed the factual testimony that has been presented before the board that was specific in nature and was factually undisputed. So what they're doing is just trying to do another advertising campaign like they do in the newspaper, which really isn't evidentiary in nature. There is nothing evidentiary in those emails. So I realize the rules of evidence in a zoning proceeding are loose, but this is just tit for tat. Well, these emails came in, which were unsolicited by us, came in from individuals. So Mr. Schlimm goes out and gets his employees to write emails after the fact. And it's an entirely different situation.
Sure, thank you. If they're of no evidentiary nature, I'm not sure why Mr. Anders is so concerned about them, but one of the things that I noted, and maybe I'm mistaken in this fact, I do not never received an email from Darrell Strunk, to my knowledge, and I'm not aware of any emails from Heather O'Donnell. So if that's the rule, then two of the witnesses that were proposed tonight by the objectors are outside of that scope.
Well, the hope in having you review the documents, you meaning counsel, that you would look at them and say, there's no harm, no foul here. It doesn't say anything that hurts or helps, let them go. But if in fact we continue to have objections, then the board has to determine what it wants to do. Now, Mr. Lehman has suggested, well, if we exclude these emails, then we exclude all the emails that came in before. That's the only testimony you're going to hear will be from people who have actually testified. And if you do that, and Mr. Wolf then wants his people to testify, I'm not sure what I can tell you there, but that's where we are right now.
Right. I mean, I certainly, from my view, I think that this does have to come to an end and that we don't need to reopen every single time we hear, from an individual. Like any public comment, we're not obligated to engage with it. I guess, I'd like to hear from the people that, are on today, but at this point, Mr. Wolf and you, and I think all of us here can agree that there has been ample notice to be involved in these proceedings. They've been happening since February or March of 2019. It is now March 2021. There should be some sort of cutoff date for something that isn't, exigent.
I agree with you. Although we have to acknowledge that we've read these emails. We had no choice. We didn't know who they were from. We didn't know what they were. We opened up and read them. So we have looked at them, but other than that, I do think that what Mr. Lehman read about our intentions February 9th are true. That was,
And I would tell you that if in fact you will rule that these emails should not be part of the record, then I think you need to rule that the other emails are not part of the record. And I don't think they have been, by the way, from what I'm seeing here.
They weren't formally,
They were not,
All right, so they're not part of the record formally, and that you will be hearing, you'll be making your decision based upon the testimony and evidence that was presented at the hearing. If that's where you want to be, then that's fine, but make that as a motion now so we don't have the same issue again.
Well, what was the impetus for reopening things at all last time anyway? The email from Girlstrunk, or was that someone else? I don't remember.
The impetus was emails that we received.
Right,
And
well,
the question was whether we should just accept them as is, or whether there should be testimony.
And the board said you wanted to have testimony. I think there was even a statement to the effect that people didn't want to voluntarily testify, you would be willing to subpoena them. And you left it, and then Mr. Karasek said it was up to me to get the ranking people to testify. There was nothing that, Mr. Wolf said at that time about him having witnesses from his side to come in and testify, and we're hearing that now for the first time. My understanding is we were gonna round up these people, bring them in to testify, and we truly stated we were gonna close the record after that, and now we're into another leg of this.
I don't know that we clearly stated we were gonna close the record after that. I simply indicated that there had to be some cutoff point. At this juncture, if the question is letting some of the emails in or none of the emails in, I'd say let the emails in. And the board can take the consideration of them that it wants to take. We're not gonna have any testimony.
well, the board scheduled this meeting because you wanted the testimony. Ms. Strunk's letter was referenced in the, transcript. It was referenced last time. So I'm surprised Andy doesn't have a copy. I had thought you would make copies and give them to all of us.
Yeah, that's where I got mine.
Yeah.
I got mine that night. I was seeing it, I have both the Jasmine Mosley's email and the Strunk email.
Same thing here. I can't imagine Andy wasn't.
Well, I can tell you it's not in my file.
I have a question, Attorney Farry, you said that you had several people here that are willing to testify. Are any of them, people who had sent the emails
And
in?
we have Gerald Strunk, who I believe is on the line. We have, Terry Fagan, who sent an email, and I have one other individual who didn't send an email, that was a former employee of the hotel, and I specifically raised that in the last transcript, that if somebody else comes forward and wants to testify, and Ron said, they would be permitted to.
I'm not sure how that's different from,
Well, it would be under oath.
forward, so
It would be under oath, as opposed to,
I have the three
email.
individuals on the call.
Yeah, right.
The point is, Heather O'Donnell, I believe, is the individual that came forward, there was no email, and it seems like there's a double standard here, that she's gonna be allowed to testify, because she came forward, but the three individuals who have, come forward on behalf of, Water Gap are to be excluded, as I understand.
If I could be heard again, I'm going to throw another wrench into the proceedings that I don't want to throw in. Mr. Wolf has had the opportunity of almost a month to review the emails that were previously submitted to the board. He therefore had an opportunity to prepare for cross-examination if these individuals testify. Now he expects us to observe these emails that he's presenting for the first time in the middle of the hearing, and now we're supposed to prepare for cross-examination. It doesn't work that way. And to believe that these people, as he just said, unsolicited, wrote those emails is almost, we'd have to be childlike to believe that. So I stand by what I said before. Any emails that came in after the last meeting should not be heard.
It seems that the trainer is becoming more and more concerned with the, content of the emails from his original statement. Again, I have no objection to all the emails coming in, the board taking into consideration of them at once. I don't think we need more testimony in this case.
Why I don't necessarily mind that idea. Why not make today, the last point? Here are the people that are here and nothing beyond. Then we can go to, waiting for Judge Zulick's decision or filing a stay or, we're taking a vote at that point. Not today on a vote, I will say that. That wouldn't be today, but at some point.
Well, again, it's up to the board as to what it wants to do. If that's how you want to do that, then have a motion made, see if you can second and pass, and then we can continue on with the public hearing, for the people that are here.
Do I hear a motion to that
I'll make
effect?
that motion. Yep.
Do I hear a second?
And that motion again is what, just so I know.
To accept all of the, presentations, came in emails.
That's all the emails.
I'd love to vote today, I'd like to close this hearing and vote today.
Yeah, I thought that was the whole idea, that you were gonna vote today.
Well, if that's the will of the majority. If I don't know what it is, then that's what's gonna happen. I
Motion
can't.
on the floor to
So-
accept all the emails.
So
Is there
someone-
a second to that motion?
But we're not gonna hear testimony on those emails. We're
No, we're
just
just taking the emails,
That's it.
and then whoever's gonna testify today testifies. If it can get done in time, I don't know, it's already pushing 5:15. And then you would close the hearing,
Right.
then determine if you wanna set a vote date out in the future for like a week or so, like we did the last time, and then go from there.
What say you guys?
So the motion
So let's-
is to accept all the
I'll
emails,
second
and you're
it.
closing the record today after the testimony presented.
Okay.
Is that the motion? Accepting all the emails and
That's the motion.
closing the record today after the people testify.
Okay, heard that motion from Mr. Barrett. Mr. Levenheim has just seconded the motion. All in favor?
Aye.
Aye. Motion is adopted.
You need to, mark and receive as evidence the Gerald Trump email and adjust the votes. They're not a record. I believe Mr. Fagan's email as well. Those are the ones in the last one.
Because they will be accepted.
Yeah, I don't have that portion of the file with me, we can make copies. Make them part of the record maybe after we're through here, but try to get the testimony in if we can, because I know Mr. Lehman has a schedule. Well, I also understand you folks. Yes, there's 7 o'clock, there's zoning hearing first, so.
Yeah.
I'll put them in the back.
All right, so that being said, Mr. Ferrari, and/or Mr. Lehman, and/or Mr. Andrews, you guys are on. Okay. Gerald Strunk, you on the line? Is Gerald on the line? We need to make sure people are unmuted.
Ms. Strunk?
Gerald Strunk?
What's your first name?
Gerald, G-A-R-Y-L.
Can you just scroll to see if there's someone there? But
We didn't do that.
no. Okay, so Julia, click the arrow next to stop video. Oh, all right.
Yep.
Yeah.
Please stand by, everyone.
Oh,
I'm sorry.
it happens, it's inevitable.
My guess is,
Yeah.
oh, okay.
You can get them lined up now. Yeah.
Yeah. Yeah. Then,
Have the other.
okay.
Back on.
The other thing that looks like Gerald Strunk we have a couple phone numbers, you wouldn't have his phone number. Yeah, the phone number I have is
Well, this is happening. We can sign this.
Is that it, or is there a second? Heather O'Donnell seems to be one. Well,
Yeah, I think it's just.
all I really need is that.
Robert, that's the ordinance.
Yeah, it's tough to tell, because the one that says user one, rec something. That's the call.
Mr. Ferrari, if we don't have Miss,
I can unmute everyone and then see if they're struggling to unmute themselves.
okay.
Okay, try that. Okay, here we go. You can also chat, so.
Hello?
I've sent, it's a little thing that'll send out a,
Is Ms. Drunk on the line?
Darrell asked that you give her a few minutes.
We don't have a few minutes. Let's go on to the next one. Come on.
Heather hold on, Ms. O'Donnell has not sent an email in. She's, what is her status?
Okay, give me just a moment, I'm gonna remute everybody, and then you're gonna have to unmute yourself.
Okay.
Hello?
Yeah, who's that?
Is that Heather?
Yeah.
We're waiting for Marcia to come back.
Okay, I think Heather's on though, Julia.
Okay, yep, and Marshall, can you hear us?
Yes, I can hear you.
Carry on, thank you.
All right, so my question for Heather.
Heather is a former employee. She worked there from February 2000.
It says on the record, because we don't have Ron here.
Okay, wait for Ron. Mr. Wolf was questioning, Gerald Strump's not yet on the line, hopefully she will be soon. We were gonna put Heather O'Donnell's testimony on first.
I'm here.
Okay, Heather, hold on for a second. Heather O'Donnell is a former employee. She worked there from February 2020 to, I believe, October 2020. And she was a counselor, and she would testify that there were counseling activities going on up at the inn as well as other activities. The record at the last hearing did provide that if we find somebody else that was able to testify, that they would be able to testify today, and that's why we arranged that Heather O'Donnell testify. She did not write an email. I did advise Mr. Wolf yesterday that we would have her testify. I just assumed that you would, I think I sent an email that she was a former employee, but I assumed that your client would know her name as a former employee.
It's not a matter of not knowing who she is. The question is, there was great objections from the other side as to the folks who came forward, as you've indicated, on behalf of Water Gaps, to their testimony. The compromise was that anyone who had written an email up to the last meeting would be allowed to testify. So Donald does not fall within that category. So if you have an open end for anyone who comes forward and you're able to find and present.
No, it's not an open end, because the last time we said it would be this meeting and that would be you. You're the one who goes past that.
I'm not even going past.
The members of the board, it was specifically stated last transcript that we would be permitted to do that. So if we're gonna change rules midstream and not allow Heather O'Donnell to testify, I'm gonna strenuously object. I mean, that was what we agreed to at the last time.
My understanding was that the objection was that I was now presenting 3 individuals who had come forward since the last meeting and asking them to testify. Now,
Of whom we had no notice until tonight.
I had noticed Heather O'Donnell yesterday.
I specifically said at page 290, what if another person comes forward to testify, and Ron said, I think the record is open again at that point. And that it was my understanding that we were gonna be permitted to do that. We went ahead and we did that. And I think we're what we talked about at the last hearing. And now the Thomas rule saying he wants to change that, he didn't object the last time, and that was put on the record. It's a person who worked there. Certainly Mr. Schlim should be familiar with the people of his employees. She worked there for 3/4 of a year.
It's not a question, again, of being familiar with who the person is. The question is what the intention was of the board in continuing this hearing last time. There were some emails that had come in, and my understanding was that's why it was held open. And I absolutely said, well, what if, additional people start sending in additional emails, and it was intended to be cut off. Now, Mr. Ferrari is bringing someone in who is, as they have located since that time, as another disgruntled employee to testify against the project.
And that's exactly what we agreed to at the last time. And if you didn't agree to that, you should have objected to it. You didn't. Otherwise, I wouldn't have arranged for it to testify. I did it in the strength of what we agreed to at the last time. We also agreed that this hearing would be the last hearing for testimony, and then the board wanted to make a decision tonight. That's what we agreed to. So if you're gonna rule that I can't do that, you're pulling it right out from under me and going against what we agreed to on the record at the last hearing. Board, I believe that Mr. Ferrari is.
Let's proceed with Ms. O'Donnell and, Ron, as always, will be, vigilant about any objections raised during the line of questioning. Let's go forward with finality.
Heather, are you there?
Yes, I'm here.
Okay. I'm gonna ask you some questions and you're gonna testify now, but first the court reporter is gonna put you under oath.
Okay.
Mr. O'Donnell, this is the court reporter. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Heather, can you state your full name for us?
Sure, it's Heather O'Donnell.
And Heather, where do you live?
I live in Bethlehem, Pennsylvania.
Okay. And what is your profession?
I am a licensed professional counselor.
And is that a license that's issued by the Commonwealth of Pennsylvania?
Yes,
And how long have you had that license?
since 2014.
And can you tell me just generally, what does a licensed professional counselor do?
Provide mental health counseling, psychotherapy, individual groups, families.
And in 2020, were you hired by Water Gap Wellness?
Yes.
And when in 2020 were you hired?
I was hired actually in November of the previous year, 2019, and then came on board when I guess when the inn opened in February of 2020.
And how long did you work there?
I worked there from February, I think it was the 2nd, until October 11th of 2020.
And when you worked for Water Gap Wellness, where was your place of work?
My primary place was an office at the Water Gap Wellness Center in East Stroudsburg.
And did you have occasion to go to the inn?
Yes.
And for what purposes would you go to the inn?
We we could go to the inn for various reasons. We could go to meet with upper management. We could go for lunchtime. We were also called to meet with clients who didn't want to come to treatment, things like that. Sometimes to provide counseling sessions at the inn when clients wouldn't come to the center.
So is it your testimony that from February 2020 through the middle of October of 2020 that you performed counseling services at the inn?
Well, I will clarify that and say it was probably sometime late August, early September where we were instructed that we were not allowed to do that anymore.
And who instructed you?
It was via email from Joe Schlimm.
And and why you were instructed not to perform counseling services there anymore?
I don't think the email explicitly said why, but we were also told to not talk to anybody in the community about what's going on at the inn, not to answer any questions, and to refer any inquiries to Joe himself.
Okay, and that was in an email?
That was in an email, yes.
And that was from Mr. Schlimm?
Yes.
Okay. And what was it that was going on in the inn up until the point where you got that email? What was happening?
There was different, group therapy sessions were done there, family therapy sessions, individual sessions were done there.
When you say there, you mean at the inn?
At the inn, yes.
Okay. And you, in fact, participated in some of those?
Yes.
Okay. So this testimony is based upon your personal knowledge. It's not what somebody told you. It's actually you were there and you experienced it, correct?
That's correct.
Now, were you aware that medications were being distributed at the inn?
I was aware that medications were being distributed at the inn, yes.
And how were you aware of that?
I was aware of it from the nursing department, from my direct supervisor, and also directly from the clients when they would talk about how they weren't receiving the right medications, or they didn't get them on time, or they were told they couldn't get them, things like that. I also witnessed it at lunchtime during the day. I'd see medications being distributed.
And tell us exactly what you witnessed.
Medications were stored in a locked medication room, and a staff member would bring the meds out. Clients would line up and get their meds.
And that was at the inn?
That was at the inn.
Now, did that continue beyond the day that you got Mr. Schlimm's email?
Yes, I believe so.
And you said that the medications were placed in a locked room and then the staff at the hotel would distribute them?
That's correct.
And you said something about people lined up to get them?
Yeah, the clients would come to the nursing desk or whatever. Yeah, there's like a nursing desk outside the med room. That's where they would get their meds.
I have an objection. What we've heard so far is cumulative. Are we going to hear something new from this witness? Because, the strict rules of evidence don't apply, but we're not supposed to sit here and do the same thing over and over again.
Well, you know what? It's not cumulative, it's cooperative. Because you've had one witness say exactly what she said, and now you're having number two cooperate with the other one said. So I think it's highly germane, because it shores up the testimony of the nurse that testifies. You don't have one person, you have two, and hopefully you're going to have a third.
Was your objection as to the substance of the testimony or objection to the question being repeated?
I think the questions and the substance are repetitive.
I don't know about the substance, but I will sustain the objection on the question being repeated.
What type of, Heather, what type of individual did you have when you were employed there?
I'm sorry, what was the question?
What type of individual did you counsel? What was their problem for which you offered counseling?
Primarily, most of my clients were mental health clients. Several of them were both dual diagnosis, mental health, and substance abuse.
Did you see clients that were just mental health clients?
Yes.
And could you tell us, if you can, what percentage of the clients or patients were mental health only diagnoses
as opposed to the newly diagnosed individuals?
Do you mean on my caseload or in the general census of the,
So let's
the
start with
agency?
the next one.
I can't.
On my caseload?
Yeah.
Well, I would say the majority of them. Most of the mental health clients were assigned to me because I am a licensed professional counselor, and I have many years of experience providing psychotherapy to mentally ill people. So I did get primarily, some significant mental illness, I won't go into it, but yes. I would say probably 80% of my caseload. I think it was very rare that I had a client who was strictly substance abuse.
Okay. And did you, what type of diagnosis do these individuals have in that 80%?
Usually a depressive disorder, anxiety-related disorder, some personality disorders. That's pretty much the majority of them.
Would those individuals receive medications to help them with those disorders at the end?
Yes.
Were there individuals who were suicidal that you knew of were staying at the end?
Yes.
And how do you know that?
Because I they were my client, and I knew that they were suicidal, and they were having thoughts of self-harm, not necessarily with a plan or intent. So it wasn't. All right, I don't want to say too much, but so they had suicidal ideations, and they were staying at the end, and part of what we did was we provided one-on-one supervision for those clients.
Did the inn have suicide watches for people like that?
I don't know that it was technically a suicide watch, but a staff member was assigned to keep eyes on that person at all times.
Okay. Were you aware that people were going through detoxification at the end when you worked there?
Detox in the clinical medical sense, like receiving detox medications? Is that what you mean?
Well, there's somebody going through the process of detoxifying off of some alcohol or drugs.
I'm not really sure how to answer that. I know that we had clients there that were either high or just coming off the drugs. I don't know if they were prescribed any sort of detox protocol medically, but I do know that we did have several clients who were under the influence and just coming off medication or substances when they were staying at the inn.
You mean the addictive substances?
I'm sorry?
You mean the substances to which they were addicted to before they came to the hotel?
Correct. Many of them, I don't want to say many of them, some of them were still under the influence of those substances when they were admitted to the inn.
You witnessed that yourself?
I witnessed that via on-call phone calls.
And were you aware during the period of time that you worked there of people leaving the property?
Yes.
Tell me about that. How were you aware of that?
I was the on-call provider, and I was called by staff at the inn to help, I guess, redirect the situation. And during those phone calls, I heard things like, he's running through the woods right now. Hold on, I got to try to catch him. He's off the property, things like that. And these were all while I was on the phone with the staff person.
When you said you were on the phone, is that what you would do when you were on call?
That's correct.
Were the medications that were distributed at the inn, where would the prescriptions come from for those medications? And I think this is repetitive. We've heard this question probably 6 times, 6 different witnesses. I think you heard it once from one witness, but again, it's cooperative, it's not repetitive.
The substance might be repetitive in the sense of heard it from another witness, but we didn't hear it from her, so I'll look at it.
You remember the question, Heather?
Who prescribed the medications?
Yeah, who prescribed the medications?
The medications were primarily prescribed by Dr. Morrow, and they were filled at a local pharmacy and I believe delivered to the inn.
And, do you know what types of medications were being, handed out at the inn?
There's a large variety of psychotropic medications, some antidepressants, anti-anxiety medications, antipsychotics, some medically assisted treatment for addiction, like Suboxone, that kind of stuff.
And who would hand the medications out?
Staff members at the inn.
And do you know what kind of qualifications they had?
We knew them, and I should say I knew them as behavioral health techs that were experienced in working in a residential treatment facility, from what I understand.
Do you know whether or not the facility that is the inn had any licenses from the Commonwealth of Pennsylvania to operate a drug and alcohol rehabilitation center there?
At the inn, I don't know.
And you said, going back to the email that Mr. Schlim sent out, I think you said in August or September, I think you alluded to something to the effect of you weren't to discuss it with people outside of the employees in the inn? You weren't to discuss
That's correct.
it with employees? Do you know why that was?
I'm assuming that Mr. Schlim wanted to keep things private.
Conjecture, yeah, that would be sustained. Right.
Did you have any concerns when you worked there, Heather, for the safety of any of the people that were staying at the inn?
Yes, I did.
And why did you have those concerns?
Because I didn't feel that it was a secure facility and that some of the mentally ill clients that we were accepting to stay at the inn, I did not feel that they were going to be safe there.
Was there any type of security force when you worked there?
What was the question?
Was there any type of security force? Were there security guards or anything like that when you worked there?
No.
All right.
I don't have any questions.
I have no further questions. Thank you, Heather. Mr. Wolf might have some questions for you. Ms. O'Donnell, my name is Andrew Wolf. I have a few questions for you. I want to start actually with just clarifying. Your office was located at the PA Nice Homes facility on Route 447, correct?
That's where my office was, yes.
Okay. And you, in addition to the duties that you mentioned, you were a supervisor for another employee, Darrell Strunk, is that correct?
At one point in time, yes.
As part of your supervisory duties, did you have to initiate an performance improvement plan for Ms. Strunk due to her not meeting her employment responsibilities?
I was directed to do that by my supervisor, yes.
Ms. Strunk's supervisor, so you did that for her, correct?
My supervisor instructed me to do that for Carol, yes.
And part of that performance improvement plan required that Ms. Strunk complete her required documentation on time?
I don't recall the details of the performance improvement plan.
During the term of Ms. Strunk's employment, did she break client confidentiality?
Not that I'm aware of.
You're a supervisor, if you don't know about any of this? Would that have been a violation of professional standards?
Would what have been a violation of her professional standards?
If she had broken client confidentiality?
Yes.
Is aftercare, an important component of a person's counseling and their care?
Yes.
Cite, Ms. Strunk for not doing this?
I don't understand what you're asking me.
Did you write her up for not following up on aftercare for clients?
We were instructed not to discuss aftercare with our clients. We were told that there was an aftercare coordinator that would handle all of that.
My question was, did you write up Ms. Strunk for not following up on aftercare with clients of the facility?
I don't recall that.
Again, you were her supervisor.
At one point in time, yes.
Is communication and attention to detail a requisite part of a therapist's job?
Are you asking me personally?
Your witness, yes.
Okay, are you asking me if, say it again.
Is communication within your employment and attention to detail a requisite part of a therapist's job?
I would believe so, yes.
And you recall having cited Carol Strunk for not doing that as well?
I don't recall what was in her performance improvement plan, and I don't recall what she was disciplined for. I don't have access to any of those documents, so I can't say for certainty.
Did you, as part of your activities, did you become Facebook friends with any of the clients of PA Nice Homes?
No.
Relevant.
Yeah.
It's going to be relevant relative to the upcoming witness, Ms. Strong.
But the answer was no, so it doesn't matter what you want.
If you, would it have been a violation, if you had been Facebook friends, would that have been a violation of maintaining boundaries and confidentiality?
Same objection. Absolutely.
Ms. Strunk. I'm sorry, Ms. O'Donnell. You were terminated from the PA Nice Homes facility on October 12th, 2020. Is that correct?
That's correct.
You recall that? And the reason for your termination was for your failure to respond to patient calls during one of your on-call duty sessions, correct?
I believe that's what is documented on my unemployment rejection, yes.
Well, I'm going to review with you your emails about that. You indicated that your answer for not responding to calls was that you were asleep. You recall that?
Yes, that's correct.
And that was your simple explanation that you were asleep, and apparently that was not important to respond to patient calls when you were on on-call duty?
Yeah, I'm not going to answer that question. But I could explain a little bit more about why my email was short and sweet.
That's not the question to you.
Okay, thank you.
So, the point is, you were terminated for failure to perform your job duties, correct?
If that's what they're saying, then yes, I guess so. I was not provided an explanation when I was terminated.
You were actually given the option to resign instead of being terminated, and you indicated that you would prefer to be terminated. Isn't that correct?
That's correct.
And at that time, you said you were seeking further legal advice against PA Nice Homes as a result of your termination.
I'm not really sure what this has to do with the testimony regarding what's happening tonight.
That's got to be made, that objection has to be made by an attorney.
We've objected to relevance of this whole line of questioning. I mean, I think
I can cross-examine her on her.
What's germane is what she saw when she worked there. I mean, that's really what's relevant. Under her employment relationship, the employer is not relevant. I mean, if he's already established that she was terminated, I mean, to go beyond that, I don't think it's germane and relevant. And it's harassing of the witness.
Well, last I checked, bias for a witness was a perfectly acceptable part of cross-examination unless they've changed the rules.
So you've already established she was terminated. So
I fine. My question was that she was at that point indicating that she was going to try and seek, legal recourse for her termination to show further bias. Ms. O'Donnell, you testified as to, treatment, sessions that occurred at the inn, and that you were instructed not to, do that after about August or September, I believe, of 2020. So you're not aware of any implementation plans that were put into effect after a complaint was issued for activities over at the inn, correct?
Well, I do know that even after that email came out, that we were not able to have family sessions at the center anymore. So as long as we considered the family sessions as a family visit, we could still have family sessions over at the center. I mean, at the inn.
You have no knowledge of anything that happened at the inn after October 12th of 2020?
After October 12th, no, I do not.
Go to some, with respect to the inn itself, Ms. O'Donnell, you would agree with me that it was not operating as a fully staffed residential facility with security, correct?
They had no security.
It wasn't a licensed facility, from what I believe you indicated, at least, or you said you didn't know.
I don't know what the status of the license is.
So would it be safe to say that you would agree that if the facility were a licensed residential facility that did have security, your concerns with safety and security would be addressed?
I don't know how I could speculate that would be true, but they would have to have more safety protocols in place for sure.
Well, my question is, if the facility were licensed with security staff and other staff available rather than being as an inn, that address your concerns for safety of both the residents and the community?
That, objection on the basis of relevance, it's also cause for speculation. That's overruled. She said that she was concerned that, people were staying at the inn because it wasn't secured and there were mental health patients. I think that question is legitimate.
Almost done, Ms. O'Donnell, but I want to ask a little bit about the clients of TA Nights homes that you saw over at the 447 facility and the individuals that were also staying at the inn. Would you classify these as bad people?
Bad people? They're mentally ill people and people with substance abuse problems. I don't classify them as good or bad.
Okay. Can substance abuse problems afflict people from all walks of life?
Objection.
It's a licensed therapist,
But it's not relevant or germane.
Of course it is. The issue has been brought up continuously through these proceedings that the residents of the inn and the proposed residents of the facility are going to be a danger to the community. They're going to be running all over the place, causing mayhem.
There has been testimony as to the activity of people at the inn. And they have caused mayhem.
If it's a position of the objectors that they do not have concerns over individuals who may be staying at a fully licensed residential treatment facility, if it were approved, then I'll withdraw these questions.
The testimony has been the activities that have occurred, and that those are relevant to indicate what the continued operation of this facility is like. It is not an attempt to characterize people that have substance abuse issues and people that have mental health issues as bad or not bad. It is an attempt to explain the impact these folks are having on the community and a density residential district.
With all due
Your question, Mr. Fulton, whether or not substance abuse, maybe and or mental abuse affects all types of people, that was the question to which there was an objection. I think that question answers itself. I'm going to sustain the objection. Let's move on.
Ms. O'Donnell, has the facility, in your opinion, as a counselor there, has it helped people?
Same objection. That's a fair question.
You can answer the question.
What was the question?
In your opinion, as a counselor, has the Route 447 facility, treatment facility, assisted people with, their disorders?
Have the staff at the facility over at the center assisted people with their disorders?
Have people benefited from their treatment there?
Yes, I would believe so.
You had said Route 447, and then I'm not sure if we were going back. She answered the question. And I believe the question was Route 447. That's why I was asking. And then she said, you mean the end, and that's why I was asking. Okay. It's answered, doesn't it?
Ms. O'Donnell, I have what is referred to here as a Water Gap Wellness Center schedule, which lists a weekly schedule of events and meetings. Were you familiar with that document?
There were many of those documents, so which one you're referencing, I'm not sure. But yes, there was usually a schedule.
It's a calendar of different weeks and the days of the week and where the activities were to be held. Would you agree with me that the activities were scheduled to be held at the Route 447 location? Is that correct?
Yes, that's correct.
By the activities, I specifically mean the counseling activities.
All the group sessions were scheduled to happen at the center on 447. We were given the opportunity to have individual counseling sessions, either in the center, at the end, or out in the community.
And that ended after August or September of 2020, correct?
Except for the family sessions that I mentioned earlier. Those were still permitted to happen under the umbrella of they were actually family visits, not family sessions. But I believe they were still billed as family sessions to the insurance.
That's all the questions I have, Mr. O'Donnell.
Just very briefly, so your testimony, just to be clear, I don't want to beat a dead horse, but you did counseling at the end up until the time that Mr. Schlim told you not to anymore.
Yes.
Okay, but then family counseling sessions still continued after August or September, correct?
That's correct.
And you said you the testimony about Gerald Strump, you said somebody instructed you to write her up?
I was instructed to write her up by my supervisor, yes.
Who was your supervisor?
Jessica Bruner.
What was her title?
She's had a couple different titles. I don't know what it is now. I'm not even sure what it was then. COO, maybe?
Okay. And you said something about when you were applying for unemployment or responding to unemployment, you said something about you wrote an email, but it was short and sweet.
I replied directly to the question.
Okay. You said you want to know why it was short and sweet. Can you expound on that?
I'm not sure what bearing that has on the issue at hand tonight.
Okay. All right, I have nothing further. Thank you very much. Does Marshall have any questions? Oh, I'm sorry, Marshall, do you have any questions?
I'm good.
Any recross, Mr. Wolf?
Okay, with me 1 second.
Okay.
further questions, Ms. O'Donnell.
Okay. Or do you have it?
I have, is Gerald Strunk on the line?
Can I make a comment first?
Sure.
I think we're wandering off in ways here. As far as I'm concerned, the question is, was this inn offering more than lodging and food in the form of medical treatment, and was it a medical facility? Whether it was run well or badly, or it changed during this time, or whether some employees were disgruntled or some employees have something wonderful to say about it, is not as much as relevant to me as the use that this place was put to.
And I think Mr. Levenheim, the testimony was
I
addressed
should have said that before.
So I'm not sure, I mean, I understand your concern, and that's what we're trying to produce evidence to show that. I think we've done that.
If I may,
I urge you to be succinct on this and stay on this line.
Yes, sir.
if I may, is the last witness available so that we can go back and ask her if this was a hotel or a medical center?
I'm going to object to that. It's an opinion. It's a zoning question. I don't think
That witness is, that train has left the station. We're going on to another. Maybe.
Yeah, is Ms. Strunk on the line?
Gerald Strunk, you on the line?
I mean, we've been told that, give her a few minutes, but I don't hear anything and haven't.
I can't, unfortunately, I don't have cell phones with coverage here.
he skipped it the last time because he wasn't available. To the second time, he's not available.
There's another witness. Can we go on to the
Yeah,
other witness?
just go to Mr. Fagan.
Terry, you on the line? Terry Fagan, you on the line?
Yes, I am. Yes, I am. Can you hear me?
Yes.
You might have to tell Daryl to do the *6 again, because that's what I just had to do.
Terry, we can take your testimony now.
Okay.
Mr. Fagan, this is the court reporter. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Mr. Fagan, you testified, I think, before these proceedings, and I'm going to ask you questions about an email that you sent in to the supervisors on January 19th, 2021. So first of all, can you state your full name?
Name is Terrence Fagan.
And where do you live?
I live on Mountain Road.
And who lives there with you?
My wife, Mary Ann, and two of our granddaughters.
And how long have you lived there?
15 years.
How old are your granddaughters?
18 and 16.
And was there an incident on Saturday, January 9th, 2021, approximately 5:10 p.m. that you wrote to the supervisors about?
Yes, there was.
Can you tell the supervisors what occurred?
My wife and I were walking our dog in the woods, as we often would, and we came out from the trail near the water tower, which is shy of the drive up to the water gap. And as we were coming out, it was getting towards dark, and we just heard a voice that said, kind of loudly, we were sitting at the table, and they told me I was going to die if I didn't straighten up. And that kind of startled us, and we looked around, and then we saw a man standing on the water gap side of the creek, right near the creek at the end of the drive there.
Was that on the property of the former country club?
Yes, it is.
And did you find that disturbing?
I did. My wife more so, but I did as well.
And did that incident raise any concerns in your mind about people?
It did. It did not sound like someone staying at an inn to me.
Did you have any fear for your safety?
We did. We didn't know what state he was obviously agitated and concerned. We were puzzled and concerned that he was by himself at the outskirts of the property without any supervision, and also a little curious about why he had a cell phone, but we don't know what the rules are.
All right, Mr. Fagan, thank you very much. Mr. Fagan, this is Andrew Wolf. Just a few questions for you. You stated that you were concerned. You didn't call the police over your concerns with this individual, correct?
No, we didn't.
So, the concern ended as soon as you got home. That was it?
No, it didn't quite end. It just kind of was a representation of who we were fearing might be up the road.
For an inn, why should you be concerned if someone was out by themselves for an inn versus a facility where there is security?
Because we felt, since we understood that patients at the facility could leave at their own decision, and that's our road that they're walking down as they leave.
When you say at an inn, do they keep people from going outside?
At an inn?
That's my question.
No, not as an inn.
All right. So it wouldn't be unusual for someone at an inn to be outside and being able to have a cell phone conversation with someone?
No, but that would be an unusual conversation for someone at an inn, in our opinion.
Yeah, well, you heard half a conversation, right?
We only heard our half. Mm-hmm.
Mr. Fagan, Mr. Farr, I didn't ask you about this, but in your letter, you raised an opinion that these types of facilities should be located elsewhere, correct?
Yes, we do. We feel it's not proper for the zone.
So if it were put into an enterprise zone, which previously suggested as a B2 zone, that would be essentially putting it near someone else's houses, correct?
Not necessarily. It would be putting in a commercial area.
Well, let me ask you this. If those commercial areas were surrounded by residential zones, such as in Smithfield Township, that would be putting it next to someone else's houses, correct?
And it's an objective, again, it's not relevant.
It is absolutely relevant to you.
And it's beyond the scope of
It was
it
raised by Mr. Fagan in his own letter. He's opened the door.
I'm going to sustain the objection only because it's obvious that if it's put somewhere else, it's going to be by someone else's home unless it's in the middle of an industrial area.
Mr. Fagan, your concern, as I interpret it, is with security of the facility, correct?
That is one of our concerns, yes.
If the facility were licensed as a residential treatment facility with security staff, would that address your security concern?
Objection, that calls for an assumption as to what the type of security is, what the plan is.
There's been testimony that's been in these proceedings as to what the plans are for security, way from back in the beginning. This is information that's in the record.
Way back in the beginning, everybody was led to believe that that was the security that was going to be there now.
Let me
I don't
interrupt.
believe there was ever any suggestion that an inn would have that sort of security until it were approved.
Let me interrupt for a moment. The purpose of the question obviously is to say if this facility is secure and properly licensed, then there shouldn't be any concern with respect to these people. The board understands that's where you're going, so we'll sustain the objection and move on.
What questions for Mr. Fagan?
If Marshall has that.
Do you have any questions, Marshall?
No, I doubt it.
No redirect. No redirect. All right, then, if it's through, or can we find, this, Trump? I don't see anybody, first off, it's hard to tell from some of the names, but I don't see any names that weren't there before. why she's not on? I understand she's going to be on, or she has some technical difficulty.
Mr. Karasek, I'm gonna suggest that we've given Ms. Strunk two opportunities to be on. There's a lot of objection about, who was gonna be able to testify today, and they certainly had notice of that.
Let's move on.
That's up to the board to decide what to do. I mean, obviously, they can say, she's had enough opportunities, we'll move on, and if there's no other witnesses, close the record, close the hearing record, so. But there has to be a motion to that effect, so that's.
I'll make a motion that we, move on and, close the record.
Is there a second?
I'll second the motion.
All in favor?
Aye.
Aye.
So, a moment here, trying to note this. This stuff will be on the record, we'll mark these other emails then, and so everyone knows what's what. So you close the hearing record. Now again, the 45 days begins for me to write an opinion, from starting today. The last time, the board decided to wait a week so they could assimilate and figure out the additional information, and then, vote. You can do that again. Or if you believe that you have enough information, heard enough information, you can vote this evening if that's what you would want to do. So that would be your choices at this point. Either push it for another day to, again, consider what was heard and vote, or vote this evening and then I write the opinion to support your position.
I'd like to hear what my colleagues are thinking at this moment.
I'm ready to make a motion.
And your motion would be, Robert?
I'll make a motion to deny the conditional use. And I do this with some personal reluctance because this has been going on for 3 years. When it started, Lee Bauer, who was then a supervisor, and I were somewhat enthusiastic about this idea because we knew about places like this. And I think we also felt that in terms of what could happen to this country club, to have a use that would be a benefit to the community, a use that would preserve the old buildings, and a use that, above everything else, would preserve open space was a good use. And Brian Barrett joined us in the belief that we should preserve open space here, because what we knew and we know now is that a developer could come in to this parcel, subdivide it, and build probably 100 or 200 homes. We didn't want that. And by the way, this is not unique to this community. Every year in the United States, about 200 golf courses close. And in each case, the fight is always between development and open space. But I'm very dismayed that this supposed inn was used for other purposes far beyond what I consider would be appropriate in the end. And it's left me with little confidence that if we did approve this and approve conditions with it, that those conditions would be met. So therefore, I'm making a motion to deny the conditional use.
Do I hear a second?
I'll second that motion, and for the most part, I agree with Robert's statements. I did too, initially when we had our first town hall meeting. I thought it was a good project, a good positive project, but as you know, my last vote was against it, and I haven't wavered. I vote.
Before I call a vote on the question, this is the point for discussion, and before I ask the public, before making that vote, I have to say this for myself, that I deeply respect all of you who have been here for years. We are neighbors, and this, these buildings, these meetings are the places where we're supposed to work together and hear each other out, and I think for the most part that is what's happened here. I am dismayed by a lot of things I've heard here that I think in some cases are discriminatory toward people that are afflicted by the disease of addiction or any other mental illness. I do think that management leaves much to be desired. Based upon the law, I do not think that the burden to deny the conditional use has been met. And while I know that many of you disagree with this, and in my heart, maybe I would vote no because this is not a good situation, I don't think the law allows me to vote to deny, but I respect you all, and I thank you all for your time. So with that, ultimately, when this vote is called, I will have to vote no on denying it. But I appreciate the thought and the graciousness that all of you have presented at these hearings. So before we have that vote, I'll entertain public comment. Anybody have anything they wish to say at this point, either on Zoom or in person?
I think we've made our positions and our arguments clear.
Yeah, I'm just looking for public comment. Okay, well, if there is no, you want to say something?
No, I think.
Okay. All right. Well, with that said, I also express gratitude to my colleagues and every professional that's been involved in this too. This has not been an easy situation. So with that, all in favor of the motion to deny the conditional use?
Aye.
No. Okay, the motion carries 2-1. Okay.
And I thank the supervisors for their time and attention, and this has been extraordinary. Thank you.
Thank you.
Thank you, everyone. Thank you.
Thank you, gentlemen, for your patience.
Thank you.
I'm gonna put part of the record, the other items here, so if you can, Don.
Motion to adjourn.
Yeah.
Yeah. Do I hear a motion from, okay.
Yeah, I'll second that motion.
Robert Levin, I make the motion to adjourn. Brian Barrett seconds the motion. All in favor?
Aye.
Aye. Meeting is adjourned.
Complete.